Good morning, all. This application hearing is in the matter of CFI 029-2025 before His Excellency Justice Roger Stewart KC, with the sitting the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Watson, Farley and Williams. Lead counsel is Ms. Charlotte Bijlani. The defendants are represented by Hamdan Ashansi, lawyers and legal consultants. Lead counsel is Mr. Lucas Viersiegel. Thank you, Your Honour.
Thank you very much. First of all, I've read the skeleton arguments that you have helpfully supplied. It seems to me that it is probably appropriate to deal with this in accordance with the various matters which have been set out. I propose that we start with the question of jurisdiction. I'm not then so bothered as to the other matters, but it seems to me broadly that, subject to any discussions the two of you had, it would then be appropriate to deal with the question of non-disclosure and the setting aside of the original order, and then to deal with the questions which arise in relation to the extensions of time and the alleged contempt. First of all, do either of you have any comments in relation to that?
I'm fine with that suggested approach. Thank you.
My approach, forgive me, Ron.
Sorry, Mr. Peer, yes, go ahead.
My approach, Your Honour, was going to be to suggest that we deal first with the discharge application. That rolls into it some questions of jurisdiction, because dealing with jurisdiction in a vacuum, in my submission, that's perhaps best dealt with second. And also, forgive me.
No, go ahead.
Can I just clarify what Your Honour means by jurisdiction? Because, of course, there's two questions when it comes to jurisdiction. One is jurisdiction vis-a-vis the freezing order you made without notice. The other is jurisdiction vis-a-vis the underlying claim. And an application has been made in respect of the latter. And, of course, points are taken in respect of discharge via a jurisdiction argument in respect of the discharge application.
Yes, well, I had rather inelegantly rolled up the questions in relation to jurisdiction in relation to both of the first two matters. I can also see the sense of what you say about discharge, in the sense that presumably you say that regardless of what the position is now in relation to jurisdiction, if, for example, the point that Ms. Bijlani makes about the failure to challenge jurisdiction within 14 days of the acknowledgement of service is a good one, then one of the points you make, as I understand it, is that the application should be discharged in relation to either jurisdiction in relation to the freezing order, or I think you say in relation to a failure to deal with full and frank disclosure in relation to jurisdiction at the point. I mean, that, as I assume, what you're saying.
If I may interrupt, Your Honour is absolutely right. That is the case I will be making to you. And Ms. Bijlani, in her skeleton, states very clearly at the front the way that she wants the hearing to go, which is to start with committal. I accept we don't have this in our skeleton argument, but I anticipated starting the hearing with what might have been a pretty full-blooded fight as to the order in which we should take these applications. My submission to you is that you should start with discharge, for the reason my Lord just expresses, that jurisdiction rolls into both the question of whether the court has jurisdiction to hear the claim, but also whether the order should be discharged. And when it comes to priority, from my client's perspective, it's discharge before the claim. And in any case, I doubt, when it comes to the question of jurisdiction to hear the claim, you would be particularly interested in hearing that argument. And if you want to, then great, we're obviously prepared to address you on it. But I had understood your most recent order that said at this hearing, and we'll deal with any other applications you make, that the sort of parenthesis would have been applications in relation to the freezing order rather than any application you make under this application heading, although of course we'll fight about jurisdiction of a substantive claim as well. But certainly our case is that we would invite you, and for reasons I can express if they're not immediately clear, to deal with discharge first and foremost, and you'll be hearing from me on jurisdiction in relation to that application.
All right. Now, I'll hear from you in a second, Ms. Vigilani. Just in relation to, so it helps both parties, my intention is to deal today with all of the applications before me, and I don't see why there shouldn't be time to deal with all of those. It will follow, unless I take the view that I'm going to give a ruling in relation to individual matters first, which I think is unlikely, that we will be dealing, I think, with some points. For example, the committal matter, de bene esse, but I am keen to deal with all matters today and will give you a single reserve judgment. Yes, Mr. Giuliani.
Yes, in relation to the discharge application, Your Honour, whilst the supporting affidavit of Mr. Jummer refers to points of jurisdiction, the application itself does not. And the order that is sought in the application says nothing about jurisdiction at all. The first application for an order on jurisdiction is the jurisdiction application that was made much later and after the 14-day deadline.
Yes, I've got your point, as may have been apparent from what I said before, that jurisdiction was not challenged in relation to this matter until, you say, more than 14 days after the acknowledgement of service. That said, having considered what both of you have said and having had the discussion, I do think it is convenient to deal with the question of discharge, because I think that does conveniently roll up, certainly as I understand it at the moment, the questions of jurisdiction and the questions of non-disclosure, setting aside my original order. I also think that, subject to what either of you say, it will be convenient to hear from Mr. Fear first in relation to that, and then to hear from you, Ms. Vigilani, in response to that. And I would hope that those arguments, as they have been identified, shouldn't take us much more than an hour and a half to deal with, taking into account open, closing and reply. And then we might take a short break, but I suspect then we'll move on to other the other matters as I indicated previously. But do either of you want to say anything more than that, or can we move on to the substantive dispute?
Just to apologise for this piece of paper, the sun in London will rise shortly, and I'll be able to see my screen again. But sorry about that, and I hope it isn't distracting. Right, I'll put it down when I start speaking.
It's an unusual problem to have. All right. Very good. Well, in that case, Mr. Fear, we'll start with you. Can you just give me... Sorry,
My name is Fear Siegel.
Right, Mr. Fear Siegel, I'm terribly sorry. Can you just give me 1 second, and I just want to make sure that I've got in the convenient place your skeleton argument, and also that of Mr. Vigilani. Just give me... Yes, very good. Mr. Fear Siegel.
Thank you, my Lord. Your Honour. Yes, this is our application to discharge the order you previously made without notice, which we're referring to as a worldwide freezing order, chiefly on the grounds that my learned friend, when she appeared before you last time without notice, did not properly fulfil her client's duty of full and frank disclosure. You yourself remarked in the course of that hearing that the submissions made to you were not in the form that one ordinarily expects on a without notice application. The ordinary course is that the advocate is having to work against a judge who is busy with a long emergency application list and keen to move on to the next case, and when persuaded of the applicant's, or if persuaded of the applicant's case, wants to make the order and then make the next order that he or she is seized of jurisdiction in respect of. And it is usual as an advocate to say, and before you make the order, my lord or my lady, I have just to bring to your attention this argument that the respondent, were they here, would have made. And the judge says, yes, Mr. Phelan, I know what you're going to say. You've redressed that in your skeleton argument, and their response is it would have been that. And you say in counter response, you say, yeah, you don't need to address more on that. And you say yes. And then you say, could I also just take you to a document in relation to a further argument? And the judge sort of says, no, Mr. Piercing, your obligation is in relation to arguments, not evidence. I have that point from your skeleton argument. And the concern of the advocate making the application is to cut off every bolt hole that a respondent may say on a return date that the duty was not fulfilled, because the consequences of a failure to hit every box of full and frank disclosure obligation is so serious, and it is usually the party making the application that is very worried about not complying with it. I use this word lightly. It is astounding that my learned friend came before you on the last hearing and did not, either in her skeleton, address you on the question of full and frank disclosure, or in the evidence that was put forward by her client, contain any section on full and frank disclosure. And the inference from that, the necessary inference, is that my learned friend essentially made the explicit submission to you that had I been there at the last hearing, I would have made no argument to you at all as to why the order should not have been made. I would have conceded every point she put to you. And it is so plainly ridiculous that it almost doesn't bear stating. The oversight is all the more egregious because, unlike in the usual course where the court is saying, that's enough of full and frank disclosure, I've read your skeleton argument, I've seen all the arguments, in fact, you've gone far beyond, in fact, what you've thought of all these points they were never going to make, and I'm content to make the order that you seek. You, Your Honour, on a number of occasions, encouraged my learned friend to make full and frank disclosure, and she declined to accede to that invitation. And it is difficult, and I say this with respect, it is difficult reading the transcript and reading both the skeleton argument and the evidence that was put before you at the last hearing to reach any conclusion other than that the applicant simply did not know that they bore this duty, because it is, as I say, striking in the extreme. Can we start just by looking at some sections of the transcript so I can make good the suggestion that I made to you, because you may not fully remember from the last time we were all here, just why I say that my learned friend explicitly declined to address you on these matters. Can we look at page 862?
Yeah.
And if we look in the bottom third of the page, Ms. Bajlani there is talking about an investigation report you may have cause to refer to a bit later, which I think comes from a company called Scope. And she says there that although she's referred to it a bit, she can certainly arrange for it to be put before the court. And if we pick it up with what you said in reply to that as the last entry on page 862, which is, if I may, with respect, obviously correct. Well, it is up to you what you put in front of me. I mean, the obligation, of course, is to put in front of me anything which might be said on behalf of the other side. That's I think, the first time that you remind my learned friend specifically of what her obligation was when appearing before you.
Yes.
Forgive me, I've got a bit of a duff reference here.
Yes.
If we move on then to page 864,
Yes.
there is there in about the middle of the page a discussion about whether there's a need for a worldwide order, and then the last clause of the sentence which you said to Ms. Biljani says that's where your focus was at the moment in relation to worldwide or domestic, together with the general question as to whether there is anything which needs to be brought to my attention. So that's without saying, without about as explicit as it gets in terms of a nudge nudge and a wink wink as to the duty as to the duty owed. Can we look now at page 870?
Yeah.
And at the bottom entry, okay, I have read that, you say, and then you say, and are there other matters that you want to draw to my attention? Any particular reasons why the defendants say that they do not owe your clients money, or they have got a defence to these claims, or indeed anything else which you should bring to my attention? So that is a third time that my lord specifically says to Mr. Bislani that there is a duty to make full and frank disclosure. There was, I was pretty sure, another reference which I don't have at my fingertips, where you specifically identify that the skeleton argument, I thought there was a section where you specifically identified that there's nothing in the skeleton argument. If I just have a moment, Your Honour, I'm sorry, I thought I had a reference to this, but I may.
I think it's in your skeleton.
To find it.
Apologies for interrupting. Could I just ask Mr. Fairseagle to just name the tabs that he's referring to?
I'm so sorry.
I'm struggling.
I apologise. I apologise.
Thank you very much.
I'm afraid I find the DIFC bundles very difficult to deal with, and so I've downloaded them. But that, because you can't highlight it in the online. Forgive me. Just give me a moment. Let me tell you where we are. That is in H2. I can't find it immediately, Your Honour, but I suppose it probably doesn't really matter because of those other three references. But suffice it to say that there was nothing in my learned friend's skeleton argument, which under the heading full and frank disclosure, which I think is certainly I've never drafted a skeleton for a without notice application that doesn't include such a section, or indeed evidence in support of one where I've done that on behalf of a client that doesn't include that sort of section. And there was also, as I say, nothing in the evidence specifically under that rubric. This is all extremely important. My learned, those who instruct me have put in the skeleton a reference to the case of Tugashev. I wonder if Your Honour has those paragraphs at the forefront of his mind, or whether it might be helpful to turn those up now.
Sure.
If we're going to look at them, that's in the authorities section, which is section J. And the authority Tugashev is at tab 15. And the relevant test that I wanted to bring to your attention is at page 1470 under the rubric the law.
Yeah.
And I wonder if I might ask Your Honour just to read.
I think I'm getting some feedback, or someone else. Can people who aren't speaking turn their microphones off, please? Yes, paragraph.
Your own line is, for me, slightly shaky. Your Honour, can you hear me?
I can hear you, yes.
Thank you, Your Honour. If I'd ask you just to read those, I think 7, no, I'm afraid there's slightly more, 12 sub-paragraphs.
Yes.
I just want to, by way of some exposition of the importance of this point, take you. I should say also that these paragraphs have been specifically approved by the Court of Appeal in a case called Dermamed. I'm afraid we don't have Dermamed in the bundle, but we do have another case in the bundle which references the approval in Dermamed. So I can take you to that. If that's...
I'm pretty well familiar with the lady, Mrs. Justice Carr's statements there, and I'm also aware they've been approved.
And forgive me, Your Honour, the line broke up. You said you're also aware of
that they've been approved by the English Court of Appeal.
Yeah. Well, perhaps there are some further cases on the nature of the duty of full and frank disclosure and the consequence of its breach. If Your Honour is well aware of them, perhaps if necessary, we'll come back to it later. But I might just leave it there for now. Can I start then by addressing you on precisely what in fact happened?
Just on that, if there are references which you want to give me in relation to that, it would be helpful to have those references.
Let's turn those up now then, just very briefly. Perhaps we could look at the case of apparel, which is at tab 28 of the authorities section. I'm afraid I don't know the letter of the authorities section. Is that a problem for you? They're already on the screen.
I've got tab 28.
Thank you, Your Honour. And if we could look, please, firstly at paragraph 107 on page 1748. That must be a wrong reference, forgive me. 1764.
Sorry, which paragraph?
Forgive me. It's paragraph 28 on page on bundle page 164. And the point I draw out from that quotation there, from the Lloyds Bowmaker case, is in the middle of the first quoted paragraph, which is that if he does not comply, he will be deprived of the fruits of his order without consideration of the merits, and irrespective of whether, had he made such disclosure, he would or would not have obtained the order. Although, of course, I accept there is the court does have a jurisdiction, notwithstanding the breach, in fact, to continue the order, although the authorities show that that's a jurisdiction that should be exercised sparingly.
Yes.
The other references I just wanted to bring to Your Honour's attention are in a case called Yukon Invest, which is at tab 27.
Yes.
And firstly at paragraph 107, which I think is on page 1748.
(1748).
Yes. And this is again to deal with what might be called the materiality point, which is that it is no answer in response to an allegation of a failure to meet the duty of full and frank disclosure for the respondent to a discharge application to say that had the point been made, it would have held no sway. For the reasons Mrs. Justice Carr set out, it sits ill in the mouth of a party who has failed to bring matters to the attention of a court in circumstances when they themselves excluded that party from the court, to then say, well, if they say they wanted to say this, but if they had said it, it wouldn't have made a difference anyway. That is the price that an applicant for a freezing injunction or any other ex parte application pays as the cost of excluding the opponent from the hearing room.
Yeah.
Now can I start by addressing on what exactly was not done at this hearing? Can we look, please, again at the transcript?
Yes. I've got that bundle, tab H.
Your Honour is ahead of me then.
Yeah, which page?
I would like you please to look at page 865.
Yes.
And if we look right at the bottom of the page, we have here an absolutely standard question from a busy judge running a long list who relies on the ex parte counsel for the applicant not to mislead and not to do anything underhand, or rather to make sure that they haven't made a mistake in what they and how they address the court. Forgive me for over-egg the pudding by suggesting by mentioning the word underhand. This is an absolutely par for the course question from the court, where they say, is this the standard order? Because I haven't checked. The court can't possibly do that. It takes about 20 minutes to go through two orders side by side and make sure it's the same word for word. And in any case, the judge has counsel bearing a duty of full and frank disclosure to assist them. And so you ask here, is this the standard? As I understand it, I've not checked, but this is the standard order. Is that right? And if we go over onto page 866, Ms. Bijlani replies, that is right. Yes.
Yes.
That is not true. This was not the standard order. Could I ask Your Honour to turn up? It's not in the bundle, I'm afraid, I don't think. Someone will correct me if I'm wrong. But what is the standard order in Schedule A?
Sorry, Schedule A, are we now?
Forgive me, Schedule A to Part 25 of the RDC rules, which is the standard order on a freezing order.
Yeah. Yeah.
And can we look at page 4 of 7 of that standard order?
Yeah.
And we see at the top of the page, at what is in the standard order, paragraph 11.2, the bracketed section, this order does not prohibit the respondent from dealing with or disposing of any of his assets in the ordinary and proper course of business. Your Honour will know that that is a centrally important tenet of a freezing order and the purpose of a freezing order, which is not to provide security to an applicant and is not to prevent a respondent from carrying out the ordinary course of their business. Its focus is narrowly and solely addressed to the question of improper dissipation of assets in avoidance of a claim. The section is bracketed in the draft order for the plain reason that not all respondents to a freezing order will have a business or will have legitimate businesses. But if you are suing two companies and a man whom you allege to be a businessman, it is obvious that if you are going to remove this section from the standard order, you need to tell the court that you have removed it. Because any judge making a freezing order would expect, particularly against two businesses, would expect this provision to be in there. In support of the submission that this is an absolutely crucial tenet of any ordinary freezing order, Your Honour need look no further than the case I know Your Honour will be familiar with of Lacatania shipping. We do not unfortunately have that in the bundle, but what we do have is the quoted relevant part minus one sub-paragraph, and perhaps I can take Your Honour to that now.
Just give me 1 second.
Of course.
Yeah, sorry, which case, which authority are we going to?
We go back, please, to apparel, which is at tab 28.
Yeah. Yeah.
And we look on page 1773. I'm afraid my was just loading, but
sorry, sorry, 1773.
correct.
Yes. Which paragraph?
And we look at the sub-paragraph 6 to paragraph 57. What must be threatened is unjustified dissipation. The purpose of a worldwide freezing order is not to provide the claimant with security, it's to restrain the defendant from evading justice by disposing of, concealing with assets otherwise than in the normal course of business in a way which will have the effect of making it judgment proof.
Yeah.
So the notion that my learned friend could say to you, when she had removed from the standard order the passage allowing expenditure to be made in the ordinary course of business, was about the most egregious breach of a duty of full and frank disclosure that one could come to. And the cases are, I mean, I can put in front of you an English decision if you're interested on the question of whether or not removing that particular paragraph is a breach, but I don't think it needs authority because it's plain and obvious. In answer to your question, is this the standard order? The only acceptable answer was no. I have removed paragraph 11.2 from the standard form.
Now, where's this dealt with in your skeleton?
It is not dealt with in my skeleton, Your Honour.
Fair enough. That is not entirely helpful, but
I apologise. No one more than me would have liked to have been instructed earlier. I could have. We had fantastic weather here in London this weekend, but unfortunately, that's the way the cards have fallen. It's not in the skeleton.
Okay. It would help me in relation to the propositions that you're making to identify where they are in the skeleton, and if they're not in the skeleton, for you to say so. So the first proposition you're making is that one of the matters in relation to full and frank disclosure is the failure to answer correctly the question that I put forward, and you rely on that. So that's the first matter you're relying on.
Forgive me, Your Honour. That is the first matter I rely on. I should have brought your attention to the fact it wasn't in the skeleton. It's because it might have been easier, because Your Honour might have thought, well, have I read this before? Have I not? But the answer is you have not read this before. This is a point that you hear and indeed my learned friend hears for the first time this morning.
All right.
And this breach of that duty is, we say, particularly egregious in these particular factual circumstances, because my learned friend and those who instruct her are themselves at the moment approaching banks and requiring them to confirm that they are complying with this order. Can I ask you just to look at H5 very quickly?
Yes. Hang on a second. Yes.
Just loading for me. This is an email apparently from someone at Standard Chartered Bank. We don't know what the claimants have said to Standard Chartered Bank, because we just have an email from someone called Haya Al-Bawab saying, "Hi, Licia, as promised, please see attached." But we can assume that it is the sharing, I think fairly assume that it is the sharing of the freezing order, because Ms. Korf replies, "Thanks again for sharing that document, Haya. We've made internalies and confirmed that SCB have complied with all Dubai and DIFC court orders received." So they have sought and received an order which removes from it the standard form in relation to assets of the to the ordinary course of business, and are then taking it round banks and making sure that those banks are complying with it.
Now, I recall that I think in some decisions of Mr. Justice Jacob, he emphasizes the necessity when making applications to set aside on the basis of a lack of full and frank disclosure, the basis upon which that is made. Now,
Certainly, sorry, Your Honour.
Well, what I was going to say is this: I haven't looked up those decisions for the purposes of today's hearing, One of the points which occurred to me when I read the skeletons yesterday was that there was a lot of emphasis in, I was going to say your skeleton, but the skeleton on behalf of the respondent,
My skeleton, yeah.
as to the absence of normal sections for full and frank disclosure. And I saw that, and indeed, as you've reminded me from the positions before, I had myself commented on that in the hearing without notice. However, I was also thinking, where's the beef? In the sense of, that's right, but what are the real complaints here? Now, there are some complaints in relation to that. But first of all, is what you're now relying on set out anywhere in your application? And secondly, do you need permission from me to, on your case, to amend or enhance the application in order to take account of these points? I'm going to ask Mr. Bijlani to intervene in relation to this in a minute, because it seems to me that there are two questions. One is whether or not you accept that you need to make any amendments. And secondly, if you do, what she says about that. And if you say you don't, whether she says. I confess at the moment, without having looked at the application and without having looked at the authorities, my suspicion is that you do need to amend your application.
Well, can I address it in this way? I accept what Your Honour says, that the authorities require. The phrase referred to is scattergun. You can't just say there's been a duty of full and frank disclosure and they said all sorts of things which were wrong. You can't do that. You've got to particularise and say what the breach was. Obviously, if I may say so, those authorities merely state propositions which should be plain. I accept also that these haven't been raised before, but there are, you say what you describe it as the beef. There's beef, roast pudding, roast potatoes and Yorkshire pudding here. I am now setting them out for you. I don't accept that the application requires to be amended. There needed to be an application to discharge that that the order that you made. It needed to identify the basis on which it was brought, i.e. a duty of full and frank disclosure, and the allegations need to be identified. I am identifying them for you now. To the extent my learned friend says she needs an adjournment in order to deal with them, then we will have to deal with that question, I suppose. Or to the extent that if you accept my submissions, you say, well, if you'd raised these sooner, we might not have had to come to this hearing because they would have rolled over when they saw if they'd heard what you say now earlier, then there may be some argument about costs. But I don't think I would have needed to put in evidence of the matters that I am saying, because they are pure submission points. This is just a submission that's coming essentially late, but it's no more than that. These are not technically complicated points. My learned friend, after all, was there and did the application. She should be able to answer these by throwing the answer out of her cuff. But if she is saying that there is some explanation as to why she didn't draw this matter to your attention, that she needs time to set out, then I suppose I'll have to deal with that if that point is made. These are pretty simple points, though, Your Honour, would be my Mr.
Well, Mr. Fairseagle, the application itself.
Forgive me, Your Honour, I think we have a bad line here. I'm afraid I can't hear you, and you have frozen on the screen. Ms. Bijlani is still moving, so I think...
I can hear you. I can't hear Your Honour. And yes, frozen on my screen as well. I don't know if the registrar's online or Hayley from the IFC courts.
Yes,
Hi.
the Justice Stewart is currently experiencing network problems as is obvious. He should be joining again shortly.
Okay, thank you.
Can you hear me?
Yes,
Yes,
Judge.
Your Honour. Yes.
I'm sorry, my DIFC teams decided to take that moment to update itself and eject me from the system, for which I apologise.
Well, we're grateful to have you back, John.
The point at which we left was when I was saying, but I think you probably didn't get, that I was looking at your application,
Yes.
Mr. Siegel, and your application is to be found in bundle B, and it is the application at tab 4 to discharge the freezing order, and that application refers as the ground the reasons set out in the 5th affidavit of Mohammed Ahmed Ramadan Juma, and that witness statement, I think, if we look at paragraph tab 11 of section E, starting on page 602, contains the material on which which is relied on, and that starts at 4 at 605, and there are a series of points, including that I'd asked numerous questions, etc., and if one looks at what's being put forward, 25, this necessitates substantial factual input, etc., and then 27, what might be described as general points, and then it moves on to effectively failure to advise with undertakings. Now, it seems to me that in the circumstances, the specific points that you are making, and I accept this is no fault of yours if you've been very recently instructed, are ones which ought to have been brought to the attention of the claimant, and they ought to have been brought to the attention of the claimant probably in the application, but certainly in sufficient time before you introducing them orally. Now, can I ask you, first of all, just simply to list the points you're going to take? The points you've taken so far is that in response to a specific question as to the form of the order, the answer given was incorrect for the reasons you've identified. Can you just identify the points that you're going to make which are not in your skeleton argument, please?
I can, of course, I'll do that. If you're on, I also have a submission to make to you about a memo, which I hope I don't forget. So if I don't, once I've given my list, if I stop talking, perhaps you'll just make sure I don't move on too quickly. Yes, the first is the departure from the standard order in the manner that I have already addressed you on. The next is a further and second departure from the standard order in relation to the provision of a bank guarantee.
Yeah.
There are other points which the rest of my points bear both on the question of discharge. The rest of my points not raised in the skeleton argument bear both on the question of discharge and of full and frank disclosure.
Right. And what are they?
Those are that whether or not there is a good arguable case. And my client's case is that there isn't, for a number. Would you like me to enumerate the sort of sub reasons for why there isn't a good arguable?
I mean, the skeleton does I think, address good arguable case to at least an extent, but just identify the basis upon which you're going to put it before me.
Yeah, I address it in an updated manner, if I can put it that way. The first is that the DIFC claimant, the first claimant, has no case at all.
Because
they have suffered no loss, and because because it was not a party to the agreements which are alleged to have been breached.
Right. Okay. So it's simply that the relevant agreements are with other entities within the overall claimant group. That's your point.
Yeah, but claimant one is out of here, and that has relevance later on when it comes to the question of jurisdiction. But it's not just I'm not party.
I don't want argument, but I just want enough to understand what the point is.
Yeah, well, that's point number one in relation to claimant one. The second point about good arguable case is that this claim is incomprehensible, and no party has any claim at all, because this claim is not set out either in the evidence that was put before you at the without notice hearing, or in the evidence that came subsequently, or in the particulars of claim, in a manner which sets out how this claim sum has been calculated.
Sorry, Your Honour, can I just ask, where is this argument in the skeleton argument?
Well, what I'm doing right now is enumerating the things which aren't.
Miss Vigilani, Mr. Fierce-Eagle has accepted that these points are not contained in the skeleton argument. And what I am asking him to do, I'm going to hear from you in a minute, don't worry. I'm asking him to identify what points it is he wants to make, just so you can be clear about where this is going. I'm going to ask him in a minute to say what he says I should ought to do about it. I'm then going to ask you to deal with it. But at the moment, I'm in advance of that argument. I want to see what the scope, the matters which Mr. Fierce-Eagle wants to argue, but are not set out in the skeleton argument or the evidence, are before coming on to that. So, dare I say, but bide your time. Mr. Fierce-Eagle.
I think the remainder of the arguments that I want to make can fairly be described as either included in the skeleton or are developments from matters raised in the skeleton that I put in a slightly different way, but are nonetheless points that are in the skeleton. I think I can list. I can go through them.
No, what you're telling me is those are the main points, and you would regard the rest of them as being legitimate developments of that. And I'm anxious not to hear your full argument now for reasons which are probably obvious. Very good. And can I ask you that in relation to the points you've identified, the two failures to the two departures from the standard order, and the two respects in which you say there is no claim, one, the DIFC claimant having no claim, the relevance of that being anchoring, I assume, to jurisdiction, and the second being that none of the claimant entities have a claim for reasons which at the moment I don't fully understand, but which you've said are incomprehensible. I'm not going to ask you. You accept that those points are neither in the application nor in the affidavit, nor can fairly be described to be within the skeleton argument which was served on behalf of your client last week.
I think that, well, there's obviously a scale. Some of them are obviously not there, like the ones the first point I made to you about that. Well, it's not certainly not particularized in the manner that you said, where's this in the skeleton, because you haven't read it. And I think perhaps that's, that says as much as need to be said. And the other matters I think I have read, I said to you that I wanted to address you on. I could find a hook to hang them on in the skeleton, but they concern for. But I accept that, for example, when I say the claim is incomprehensible, that's going to involve me taking you through some arithmetic that is not set out in the skeleton. I think I have to accept that. Right. What I wanted to say.
Sorry, you did say you wanted to make another submission, Mel. Just make that point, or make another point before you've got it.
Yeah. What I wanted to say on that point, Judge, is that it is important to consider both the court's obligation here to come to a finding which is just, and secondly, a technical legal submission called Source for the Goose and Source for the Gander.
Well, I'm at the moment, I'm just wanting to see where this goes, because at the moment it seems what I'm now going to do, just so you're clear, is I'm going to ask Mr. Vigilani what she says ought to happen now in relation to what's being put forward. And it seems to me, just to trail my coat a little bit, there are three possible things that she may say. One is that these are all points which, although not previously put forward, she's able to deal with now, because they are points which arise on the papers and the documents, and therefore we can go ahead now, in which case we'll turn. The second is that they are points of which she hasn't had notice and she's not in a position to deal with now, and she requires an adjournment to deal with, in which case I'll hear you on that. And the third, which may be tied in with the second, is they're points that you shouldn't be allowed to run at all, and therefore I shouldn't be hearing from. And I want to see which of those three, or I'm insufficiently imaginative, if there's a fourth, what she says about that, and then I'll return to you to see what's said about it. It seems to me what you've just been said is likely to be a response to either points 2 or 3. Right. Ms. Bijlani, I take what Mr. Fear-Segal has said to be this. First, that you were in breach of your duty of full and frank disclosure. That is, as the authorities make clear, and in particular, I reference to some decisions of Robin Jacob, which I can't remember the precise details of. He emphasizes the need, both because of the seriousness of the allegations and also for reasons of court effectiveness, that those are set out. Secondly, I think he accepts, and certainly if he doesn't, my provisional view, subject to anything he does persuade me, is that you should have been given notice of this, either in the applications or certainly before today's hearing. Thirdly, he says you're in a position to deal with them now, or in any event, I suspect he'll say that a short adjournment can deal with any matters. Now, what do you say I ought to do?
Your Honour, I say that a number of the arguments should not be allowed. This application was made on the 4th of April 2025. You initially ordered in your 28th of March order, 24th of March, that the application to discharge or vary the freezing order should be made in March on the 24th, and that wasn't done. The application itself doesn't give any detail of what it is that the respondents say amounts to a failure of full and frank disclosure. And the skeleton argument of my learned friends is 55 pages long, reaching a limit of 25 pages permitted by the rules, filed without permission of the court, which should have been obtained. And it's remarkable that these points haven't been addressed in a 55-page skeleton argument.
Well, it seems to me it's pretty plain. The reason for that is that, for whatever reason, Mr. Fear-Segal has only been recently instructed, and it seems to me to be fairly plain from what has happened this morning that these points have been taken because he's been lately instructed, and the how shall I put it, attention to detail and attention to the rules has suffered something of a volte face since he's been instructed. That seems to me to be the obvious explanation, subject to anything he says in due course.
Yes.
All right. So your primary submission is that I should not allow these points to be taken at all, and you do so on the basis that, as you say, there was an order requiring the the application to be made on the 28th of March. The order was made on the 4th of April, and effectively they've been sprung on you today without notice beforehand. That's your first point.
Yes, that's right. Yes.
Is there any other? Sorry, are there any other points in relation to not being able to rely on the matters at all that you want to take?
Well, I think other than the fact that they just haven't been brought to the attention of the court before the skeleton argument, they haven't been referenced in the applications themselves at all. The application for the
Look,
discharge.
you can take it. I put to Mr. Pierce-Eagle, have these been put forward? And you heard his answers. I looked at the application. I've gone through quickly this affidavit of this affidavit of Mohammed, well, of the respondent's lawyer, and I have looked again at the skeleton argument, and it certainly seems to me at the moment that there is certainly not, I will describe as fair notice of any of the points that have been taken. Whether a hook can be found for them is another matter. So you can take that as read, but the real question I think you have to address is whether or not, despite those failings, and given the matters they go to, he shouldn't be allowed to take them at all as distinct from an adjournment to deal with matters.
Well, Your Honour, I think I can deal with the matters now. I don't think we need an adjournment today.
Right.
And if I can just take you to paragraph 11 of the freezing order, if we can bring that up, please.
Can you tell me which document you're referring to?
Yes, of course.
I'm sorry, just page 609. Okay.
Page 609. I can just bring that.
Yeah. No, we're now on a different page. We're on page 42.
It's paragraph 11 of the freezing order. I'm having a few technical issues myself, I'm afraid.
Sorry. Just to be clear, we're in order. We're in the amended order. We're in order C tab 1. Is that where we're
order
at?
C tab 1, yes. And so paragraph 11 is on page 42, which is dealing with exceptions to the order. And you'll see that it says that the order does not prohibit the third respondent from spending a reasonable sum not exceeding $25,000 a week.
Yeah.
And then paragraph 12, it says the respondents may agree with the applicant's legal representatives that the above spending limit should be increased, or that this order should be varied in any respect, but any agreement must be in writing.
Well, look, there are 2 points at the moment in relation to this, Mr. Giuliani. The first is whether or not you're happy, notwithstanding the fact that these points have been sprung upon you, to go ahead and deal with them now. And I understand you to be saying that you are, and that's fine. The second is whether this is an adequate response to the first of the points which Mr. Pierce-Eagle had made, which was that there wasn't provision for the ordinary expenditure in the course of a business. I paraphrase the matter to be put there. And the point that Mr. Pierce-Eagle, I'm sure, will say in response is this is dealing with a different matter. The particular way you've got a business is, there's expenditure in the ordinary course of business as distinct from living expenses. So he will say this isn't a response. But I'm at the moment on the first point, because if you say that you're content to deal with these points, notwithstanding that you haven't had proper notice of them, then we will go ahead and we will go through and that will be an end of it. If, however, you say, as provisionally it seems to me you would be entitled to, that you want to have at least an identification of what the points are and a opportunity to see whether or not you wanted to put in either any further evidence or at least have time to consider them, then I would be sympathetic to you in the circumstances. So that second question is one which I want you to consider quite carefully, because as I say, if you say that you just did, you're happy to deal with this matter, then we'll go ahead. Mr. Pierce-Eagle will complete his submissions, and I'll then ask you to reply on them, and we'll go ahead. So are you happy to go ahead on the basis that Mr. Pierce-Eagle develops the point which he has identified are likely to be put forward.
Yes, Your Honour, I think the point I was trying to make about the paragraphs is that an application to amend could have been made or requested in writing through the lawyers of the respondents. I, of course, have not had time to look at case authority on the point and look at this point in any detail. So on that basis, I think I do need time to just go and look at that and deal with the argument that has just been sprung on us by Mr. Fairseagle.
So what in my view ought to have happened here is this. Either in the application or certainly before the skeleton arguments, and certainly if not then in the skeleton arguments, the grounds upon which it was going to be said there had been a lack of full and frank disclosure should have been identified. And I understand that to be in accordance with normal practice. At that point, either you could have decided that you needed to put in some more evidence, you may well not have done, or at least you would have been able to look at all the authorities, consider them, and so forth. Now, in the circumstances, it seems to me that, and this is all subject to hearing Mr. Fairseagle, but at the moment, it seems to me that you would probably be entitled to an order that Mr. Fairseagle identify in writing as soon as possible. And he's done the work, I would have thought that would be within 24 hours or so. The points that you then had an opportunity to consider whether you wanted to put any evidence and put it in. And again, that would be fairly short. And then this hearing come back fairly shortly. I think probably because of my commitments, it would be next week rather than this week. And we'll go forward on that basis. Now that at the moment is how I think this could go. But if you're saying that you're content to deal with them now, then so much the better.
Your Honour, I think I need time to look at the details that Mr. Fairseagle puts forward in writing in terms of what's being relied on. In all of the affidavits that have been served by Mr. Jummer, both with the application to discharge and subsequently, we've had very vague arguments about failures of full and frank disclosure with no specifics.
Mr. Vigilani, you're pushing to an open door in relation to that.
So I would like more time to deal with the point.
Do you want the time, which I have provisionally indicated is how I see it, or do you want more or less?
I think if Mr. Fairseagle can identify the points in 24 hours, we can respond maybe within 48 hours from there.
Right. Well, as I say, the consequence of that will probably be, subject to anyone else, a relisting at some point next week because of my own commitments this week. But that. All right. Now, Mr. Fairseagle, it's taken a bit of time, but the position is this: there's no opposition to you making these points. There is, however, the position being taken, as to which I've already indicated I am sympathetic, that you should identify those points in writing, and that the claimant be given a short opportunity to consider whether it needs to put any further evidence, and if so, do so, and that there is then an adjournment where we come back at some point, which I'll seek to identify with the parties in the court next week in a minute. What do you say about that?
I wonder if Your Honour might consider rising for a moment so I could take some instructions on that point.
Of course. Awesome. And just so you're aware of the position, I'm not proposing to make an order for costs now, although my provisional view, but it's a provisional view which will be altered by the position in the round, that the costs of this adjournment are likely to have to be met by the respondents in any event. I'm not going to make an order, and I will be open to being persuaded of that, particularly in the light of what the overall result of all of this is. But that's my provisional view at the moment, if it helps in relation.
But if I can just sort of try and simplify matters, if you do end up adjourning this, depending of course on what my instructions are and what I submit to you and what you decide, my submission to you will be that the cost should be reserved. So
well, I'm going to I'm going to say that, but I'm also indicating that
I understand why my lord indicates that, and of course when I take instruct. Well, those who I'm about to call have heard you just say it, so thank you.
Well, all right. Well, half past 8. Sorry, 11:30.
Can I just
Half past. So sorry, yes, Mr. Johnny, you can
yes,
say
can I
something.
just say one point on costs? As I mentioned earlier, the skeleton argument is 55 pages long, and the rules require permission.
You may well have the point that there are other costs, points, etc. At the moment,
Yes.
I'm doing nothing more than indicating that I'm going to probably look at all the cost orders, and if you say that the skeleton argument ought to be disallowed, well, so be it. But we'll deal with those on another day.
Certainly, thank you.
All right. How long do you need, Mr. Fierce-Eagle?
I could have 15 minutes.
Yes, very well. We'll adjourn until 11:45, Gulf Standard Time.
Thank you.
I've had getting on to this call. I'm simply going to turn off my microphone and my camera so as to at least ensure that I've got some chance of getting back on.
Thank you. I'm going to leave because I'm going to try and talk to my team on Teams. So I don't think I can be in two at once. So with your leave, I'll leave the call and I'll come back.
Very good.
Thank you. Forgive me for the delay in rejoining. I'm sorry I'm a little late on.
So, right, where are?
Yes, our primary submission, and I appreciate that I may be pushing at something of a difficult, of a sticky door here, but my learned friend almost acceded to your invitation to continue today. These are not complicated points I am raising. The obligation is obviously to bring them to the attention of the other side, but one has to be mindful, Your Honour, of the context in which those authorities to which you've referred, although none of us can remember the name, developed, which was in a day before written transcripts, and to account for circumstances where the party appearing at the return date was not necessarily the party who gained the ex parte order. These are questions about which Ms. Biljani, forgive me, should have the answers at her fingertips.
Yes, all right.
And our primary submission is that the matter should go ahead today, with me being allowed to address you on the points, the new points that are not in the skeleton that I've outlined to you already. If you're firmly against me on that, then I don't think anyone's suggesting I shouldn't be able to take these points. So we would ask for there to be an adjournment on a timetable that perhaps we could hack out if needs be. But as I say, our primary case is that this is stuff that the respondent should be able to answer almost immediately. And if they can't provide an answer almost immediately, there isn't an answer. And so it is essentially a waste of court resources and the parties' resources for us to come back on another day merely for me to repeat the allegations I've just made. The further allegations of failure to make disclosure are similar to the one I've just made. One asks rhetorically.
Sorry.
Forgive me.
I didn't mean to interrupt you. Go.
Well, one asks rhetorically.
I thought you were. I thought you were winding up, but you're not. Go on.
Yeah. Sorry, that's an impression I often give. One asks rhetorically how notice of what I addressed you fully could possibly have made a difference. It's a simple point that this paragraph was removed. It either was or it wasn't, and here it was. And it's my other points are similar. And so my primary submission is that we should go ahead today with me being allowed to run the points. But if you are firmly against me on that, then it's an adjournment.
Right. I don't need to hear from you, Ms. Biljani. This is a day which was, I'm going to give a short judgment in relation to this point. This is a day which had been designated for the hearing of applications in relation to a without notice worldwide freezing order, which I issued in March of this year. There were, I think, a total of 4 applications which were going to be heard today, and it was convenient to deal first with the respondent's application to set aside the injunction. Mr. Fierce-Eagle, who appears today but has been instructed very recently, so recently that his name doesn't appear on the skeleton argument, which was served on Thursday or Friday of last week, started off by making points in relation to the setting aside of the order, which he candidly accepted, were not fairly identified in the skeleton argument which had been served. And for my part, whether those points are good or bad, it seems to me to be plain, as I think Mr. Fairseagle accepted. They should either have been in the application, or they should have been in the evidence which accompanied it, or at the very least, they should have been fully set out in the skeleton argument which was served last week. Those points, he says, are basic points, and he identified in general terms what those points were. The first of them being a failure, despite a specific question from the judge, that is me, that the standard form of order was not that the order which was sought was not the standard form of order. And he made some other points which he identified in general terms fully. He says that they are the sort of points which can be dealt with by the claimant, and the claimant should be able to deal with those points, as it were, vernacular, on the hoof. In my view, it has to be recognised that any allegation of failure to provide full and frank disclosure, still less an allegation of misleading the court, whether directly or whether deliberately or inadvertently, is a serious matter, and that is recognised in the authorities. It is for that reason that the authorities do require proper notice of the basis of the basis of an application set aside to be given. Miss Vigilani fairly accepted that these are not points, or that the respondent shouldn't be prevented from taking these points. But after some probing from me, requested an adjournment so that they can be fully dealt with. In my view, it is appropriate to grant the adjournment. Probably, if the matters had been in the skeleton argument, the matter could have gone ahead today. But it is not simply a question of being able, as it were, to deal with points. It does require looking with some care at the background, and also, given the consequences, or potential consequences for the claimant, it is one which I'm satisfied needs to be dealt with properly, so that Ms. Vigilani and her team have the opportunity to consider and identify the points. For those reasons, I am going to adjourn this hearing. I'm going to adjourn it for a short time. I'll hear the parties on the consequences and the precise orders made, although I will suggest some orders and see whether they consider them appropriate. I am going to reserve the issue of costs, although I will express in this short judgment my provisional view, which is that in the circumstances, the costs of this adjournment, i.e. from today until next week, are likely to be the claimant's in any event, although that is not a judgment. It is simply recording my present view, because in my view, this adjournment would not have been necessary if even relatively short notice had been given of the points which are being taken. As I say, that is simply an expression of traditional view, not an order.
Your Honour,
But
can I
that's
just ask, do you mean respondents rather than claimants?
If I said claim, which I obviously did from that, then I did. Yes, sorry. It's one of those occasions that yes, should be paid by the respondent in any event. I meant.
I wrote respondent to you. I knew what you meant.
Now, that's the end of the short judgment. Just in terms of the mechanics of this, the days that I have got available next week where I can hear this matter are either Wednesday, the 21st of May, or Friday, the 23rd of May. In both cases, I will actually be in a different jurisdiction, but we would be starting at 10 a.m. Gulf Standard Time, i.e. 7 a.m. British Standard Time, to avoid any disputes about the matters. I'd ask the parties, if possible, that this matter be adjourned on to one of those two dates, and I'll allow them in a minute just to discuss which of those is most convenient. I want Mr. Fear-Seagull, you to identify in writing the allegations or the particulars which you say are appropriate of lack of full and fair disclosure or failure to bring matters to the attention of the court, or indeed, if they are there, misleading of the court. I imagine that being a fairly short form document, but it needs to provide proper particulars of those matters. And I imagine that could be done in a page or possibly a maximum of 2 pages in short order. We'd indicated 24 hours, but given the time, if you want a little bit longer than that, I'd be prepared to give it to you. I also want a revised skeleton argument in advance of the next hearing, not least so I can consider the points by reference to the argument. And the point is made that at the moment you've got a 55-page skeleton, which contains material which you may well think doesn't need to be there, but doesn't contain material which does need to be there. So I will require you certainly to provide a, well, it seems to me probably a new skeleton argument, whatever parts of the old one are appropriate. And I want that in sufficient time that I can consider it before the hearing. Ms. Bijolani, it may well be appropriate for you. Well, in fact, I think it will be appropriate for you to provide a revised skeleton argument as well. And ideally, I would like those skeleton arguments 2 days, not 1 day, for the hearing. So if the hearing's on the Wednesday, I'd want them by the Monday. And if the hearing's on the Friday, I'd want them by the Wednesday. Now, would it be convenient if the two of you had a brief discussion as to those matters, or take any necessary instructions, and address me as to whether those directions are convenient or not?
Thank you, Judge. I have no manner of speaking. Well, I suppose I can call her if I know. Let me see if I've got her number on the bottom of an email from her.
Well,
yes, I do. So perhaps I might telephone perhaps speak to my clients first, and then I'll phone Ms. Bijolani. From my perspective, I could do a hearing on Friday of next week, or just to make sure I've got the right week, which I think is the 23rd.
Yes. Well,
I have a flight that evening, but that's English time. So it's probably
we're going to be starting at 7 a.m. English time, so we will be finishing by 1 p.m. English time.
Yeah, well, that should be fine.
Ms. Bijolani, just before we go, is Friday the 23rd of May convenient for you?
yes, it is, yes.
Well, in that case, could I ask you to just to see if you can agree some directions along the lines I put forward? And if you need to speak to your clients, then I'd suggest what we'll do is we'll take another 15-minute adjournment, and then I will look forward to seeing you next week.
Might we have 20 minutes, John, just so I can speak to my clients and also to Ms. Bijolani? I apologise.
Yes, of course. So 20 past.
20 past, whichever hour
Thank
it
you.
is.
Yes, thank you.
Thank you.
Very good. Is everyone on who needs to be on?
I believe so, yes. And Your Honour, I've managed to speak to Mr. Fairsigel about directions going forward. I would just like to raise one point, which is that whilst the applicants do not accept that the points being advanced are material in terms of the duty of full and frank disclosure, it strikes me as rather odd that the respondents have not requested at any time, including today, to vary the order to include the provision that is mentioned.
That's a matter which you can address in due course. It may be that Mr. Fairsigel would say that that is not relevant in relation to his primary application to set aside various matters, but if despite that I was against him, it could be included in a varied order in due course. But it seems to me that's a matter which you are fully at liberty to raise on the adjourned hearing in relation to that matter, Mr. Johnny.
To cut across you on that, Matt, Mr. Blythe didn't raise that with me on the phone. It was, of course, going to be the corollary of what I was going to say later on before we ended this hearing. So I'm going to address you on that today. And if Ms. Bijlani is willing to address you on the point as well, then great. It sounds like she is, but fabulous. In terms of directions, as Ms. Bijlani says, we agreed them on the phone.
Just slow down. I will deal with the continuation and any points in relation to the continuation after we've just seen where we are about the adjournment. Are you agreed as to what directions are appropriate for the adjournment?
Yes.
Yes,
Can one or other you tell me what you've agreed with?
It's as you anticipated, Your Honour. It's respondents to provide. I'm not sure what we'd call it, but perhaps a schedule of particulars of the alleged breach of duty of full and frank disclosure.
Schedule of proper particulars of
alleged breach of the duty of full and frank disclosure, and we agreed that would be by close of business on Wednesday. Ms. Bijlani wanted an opportunity to respond, which I have no objection, and we agreed that would be by close of business on Friday. You indicated
just in relation to that, a response either in the form of a schedule or with additional evidence, if so advised, or haven't you discussed that?
We haven't discussed that, I'm afraid. But
I wouldn't have thought that additional evidence is necessary, but in principle, it seems to me that if there was to be any additional evidence, it certainly needs to be filed by then.
Yes.
So we'll put schedule in response.
Together with any evidence, if so advised. I want to make it plain, I'm not encouraging and I can't at the moment see why evidence is necessary, but equally it seems to me if it was necessary, it needs to come in by then.
Forgive me, we said that would be Wednesday, and the response would be on Friday. And then you indicated that you'd like skeletons 2 days in advance, and we're proposing the hearing be on the 23rd. Even though, Your Honour, it's my birthday on the 22nd and Miss Bijlani's husband's birthday on the weekend, but we have agreed nonetheless that we will have the hearing on the Friday, the 23rd, with skeletons on the 21st.
Very good. Well, as I said to one of my children, he's getting a bit too old for birthdays.
Well, those who appear before you have followed that judicial guidance.
Well, very good. Those directions will appear in the order of the court. Now, one or other or both of you want to address me in relation to the continuation of the order, which absent anything else will continue as previously put forward. But if either of you want to put forward matters in relation to that, now's the time to address them. Sorry, I should say the order will continue in the form as is until the revised hearing, in the absence of any submissions which are now made.
Well, Your Honour, I would like to go back to what I said at the beginning of this adjourned hearing, which is that notwithstanding the fact that the applicants take the view that the omission of that paragraph is not material, the applicants are willing for it to go in, to make it clear.
Okay, so you're, if Mr. Fear-Siegel says that it's appropriate for the paragraph to go in, you're content on a pro tem basis for it to be in the order between now and the adjourned hearing. In other words, for the form of the injunction to be varied so as to include that paragraph.
Yes, that's right.
And to the avoidance of doubt, the paragraph concerned that in the standard order at sorry,
It's in the standard order at 11.2.
11.2 on to the schedule to part 25 of the IFC rules.
Yes, and I should say, my version of that draft is that provision is in square brackets for a reason.
Well, let's not get into that now. I'm just identifying what the order is. So you're not opposing a suggestion that the order be varied so as to include the paragraph at 11.2 of the schedule to part 25 of the DIC order. Mr. Fear-Siegel, are you content with that on a pro tem basis?
Yep.
Very good. Right. Well, the court will order that the form of order be the form of the existing worldwide order be varied so as to include that on a basis until this adjourned hearing on the 23rd of May of this year. Are there any other matters?
I should say also that is a matter that's at the forefront. It was extremely important to deal with. There are, of course, other shortcomings with the with the form of order and its deviation from the standard form in relation, for example, to the provision of a bank guarantee, which I was going to address you on.
Are you asking me to make any other orders now on a pro tem basis between now and the 23rd of May or not?
Yes, I am. I had understood that was something the court wasn't willing to do because the corollary of Melenfra not being able to, saying she wasn't able to deal with the point. But if it's been accepted,
I do think that it is difficult to have those matters being varied unless there is a pressing case for it or there is no opposition. Now, Ms. Vigilani said no opposition to what's being put forward now.
Exactly.
There
is not a pressing case for the bank guarantee right now. The fact that I don't want it to be thought that because I'm not asking for a variation to include. Forgive me, Judge.
All of your rights are reserved, including the right to ask for further variations of the order if other points go against you on the 23rd of May. But until the 23rd of May, unless you persuade me otherwise, the order will continue in its existing form with the addition of paragraph 11.2.
Yes, and I'm probably saying too much, but if Your Honour just give me one further indulgence, I don't want it to be said against me that the fact I didn't seek the order to be varied pro tem is itself an argument against my allegation of breach and full and frank disclosure. Otherwise, I'd argue all of it now. But as I understood it, Ms. Vigilani says, and the court's found she needs to have time to respond to all of these, and we just end up arguing them now. So that's all I wanted to say.
Right. Well, Ms. Vigilani, you understand the position. Is there anything more you want to say now in advance of the 23rd of May?
No, Your Honour. The arguments will be dealt with when we know what they are. Yeah.
Right. In that case, we will adjourn the hearing now until the 23rd of May on the basis of the order. Can I just ask the registry whether there are any other points about which they're unclear in drawing up the order?
No, Your Honour, thank you.
So the order will not be agreed between myself and Ms. Vigilani. We'll just receive it from the court.
I consider it sufficiently clear as to what the form of the order is, and the form of the order will come out. It will give the directions which you've agreed. It will modify the existing Moreover injunction, and it will adjourn the matter until the 23rd of May on the basis of costs being reserved until May. And for the avoidance of doubt, I am anticipating dealing with all outstanding matters on the basis that I will have read the revised skeleton argument and we will deal with them on the 23rd of May. Very good. Thank you all very much for your. Thank you. Bye now.
Thank you.
Okay.